Hi, my name is Daniel Tozer. I lead the commercial technology practice at Harbottle Lewis, and today I'm going to be talking about the legal implications surrounding the gathering of data from the Internet of Things. And I work with a number of clients in the mobile industry or trying to get the services into the mobile industry, particularly on data issues. And as was mentioned, I have a background in the mobile industry myself. I spent 9 years at Vodafone in a variety of legal roles looking at new products and services. How do I follow a talk that features the words Wi-Fi enabled vibrator? And they're also featured the introduction saying you're not here to give the scare stories. No, that's my job as the lawyer. So I will give the scare stories. But I'm looking at data from an IoT perspective. And clearly IoT provides some fantastic opportunity to gather a huge amount of very rich data about your customers, your suppliers, your contacts, and people who have no real relationship to your business other than they come into contact with your products and services. So to what extent can you just grab that data, do anything you want to do with it? So I think this is not a very long presentation, so I want to give some structure to it, some highlights to it. So if I was going to say from a legal perspective, from a data perspective, you should be thinking about 3 different questions. One is, what is the type of data you're gathering? 2 is, what do you actually want to do with it? And the third is, what is your role in that process? If you have clear answers in your minds to those 3 questions, then you're going to go a long way to working out where you fit in the legal framework. So let's just get a bit more detail on that. So this is the eyesight test for, I was going to say anyone at the back, but probably anyone at the front as well. So this is a list of the 8 principles under the main act that we think about from data protection perspective in the UK, where if you're doing anything with personal data, processing means anything, collecting it, holding it, looking at it, analysing it, transferring it, hosting it, anything you can think of is processing. If you're processing personal data, you need to make sure you're complying with the data protection principles. We're not going to go through all of these now, but let me just highlight probably a couple. So number 1, which is, what colour would that be? I don't know, peach, apricot, something like that? Orange, I say orange. Personal information must be fairly and lawfully processed. That's a great lawyerly phrase, isn't it? What does that mean, fairly and lawfully processed? Well, it depends on what the data is and what you're doing with it. Now, an easy way to show fair and lawful processing is consent. So the person to whom the data relates has consented to it. Let me just do one more, which is the one over there, the yellowy one, number 7. Personal information must be secure. We've heard about the fact that you are likely to get hacked. It is an inevitability. So to what extent does the law require you to prevent yourself from being hacked? I'll talk about that about that in a second. But if you remember my 3 questions, what is the data you're processing? So the first question you have to think about is it personal data or not? So personal data is any information from which you can identify a living, identifiable individual. So not a company, a person. They have to be living, not dead. And you have to be able to identify them from that piece of information, or from that information plus some other information to which you have access. If you're in that scope, that it's personal data, then you have to start thinking about the principles. And we'll give some examples in a second about what might and might not be personal data. So the second question I said was, what are you doing with it? So you have to think about the types of use you want to make of the data. So if, for example, you're gathering my data and you want to use it to sell it to a marketing company to sell stuff to me, is that fair and lawful processing if I know nothing about it, if I haven't consented to it? Don't think so. But if you're the hotel and you want identities of everyone who comes in, or a record of people who come in from a fire record perspective in case there's a fire drill, you can see why that might be a reasonable thing to do. Within the definition of personal data is a specially controlled subset called sensitive personal data. Now, this is the really personal stuff. This is information relating to a person's ethnic origin, their sexual preferences, or their medical conditions, oddly, their membership of a trade union or not, their religious beliefs, their physical condition, those kind of really personal type level of detail. If you're dealing with sensitive personal data, then the requirements are much more strict in terms of the information you have to give to the individuals, the consent you have to get from them. So to have a think about that in terms of your IoT products and services. Okay, let's have a look at a couple of case studies. and we'll have a think about that. Actually, but before we do that, I'm going to take one slide that comes in a bit later, which is the other key thing. I mentioned, think about what type of data you're getting, what you're doing with it, and also what your role is in that process. There are two key roles under the current regulatory environment from a data protection perspective. One is a data controller, one is a data processor. Anyone doing anything with personal data is either one of those two. You might be both at some times too. The controller is the entity that decides why data is being collected and what's going to happen to it. The processor is just an organization that does stuff for the controller. Might sound arbitrary or just technical, but it's really important from a legal perspective because all of the obligations under the current regime are on the controller, not the processor. So if you think you're a processor, you should be thinking about yourself and your contracts. I am the processor, that's the controller. You should be defining yourself as such. You should be having your structuring relationships as such. If you're the controller, you have responsibility for what you do and what the processors do. Okay, let's have a look at some examples. And these are some examples that Ofcom give. So I thought we'd take those. We have 3 examples here of some IoT solutions. So smart energy. So what we have here is a smart energy grid that's going to intelligently manage the power coming from a power station and being delivered to certain homes. And it's going to go further than that. It's actually going to work out in a particular home which device needs the power at any given time. So it can manage peak flows and demands. It can work out, actually, that washing machine doesn't need to be on now, but they definitely need the hot water because they're going to get washed in a minute. So it's going to manage it from an individual level in the housing, but also it's going to help the power station work out fluctuations and also the grid work out where to deliver power to at any one time. So again, going back to my 3 questions, what kind of information, what kind of data is being collected by this network? Does anybody think any personal data is being collected? A couple of nods. Anybody think no personal data is being collected? Okay, I think you're right. There definitely is personal data being collected. I mean, you can see that there's a certain level of probably non-personal data in terms of power output from the power station. It's not really personal data, how much power the power station outputs. But when you get down to the individual home level, working out when people need the lights on because they're at home, when people need the heating on, when they need the water warmed up because the kids need a bath in the evening, you can actually start generating some quite individual level information about those homeowners and those houses. And if you also have their billing information, you probably know their names. So you might know that actually there's only one guy, there might be only one guy living in this house, and you'll know when he's around, you'll know what's kind of equipment he has at home. You might even have some sensitive personal data if there are some particular power usages he makes of it. So very quickly, without really thinking about it, a purely technical solution becomes quite a personal solution. And you need to think about, are you complying with all the principles? Have you told all these individuals what you're doing with their data and why you're collecting it? Who are you sharing it with? Second example, smart health. So let's think about here. So we have a few solutions on this one. So this is the individual here, and he's going to be wearing some monitors, some wearable tech on his body that's going to take readings of his perspiration level, his heart pressure, his blood pressure, heart rate, etc., 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 maybe body temperature. And if it goes beyond the norms that have been established, it's going to warn his doctor. It's going to say, actually, Daniel's not feeling very well today. I think I'll book him in an appointment tomorrow. He's also got an intelligent pill box because he has some medication he has to take every day. And he's a bit forgetful about the medication he takes, so the pill box is going to send an alert both to him, but maybe to his carer or his doctor when he misses a pill. Maybe in the emergency services too, if it's that serious. And in the home here, he's got some smart sensors set up that are going to identify when there's movement in places there shouldn't be, probably for a burglary perspective. But perhaps when there isn't movement, when there should be. Has he fallen unconscious? Has he not woken up properly? Maybe there's some sensors that pick up water in the bathroom, on the bathroom floor. Has he left a tap running? Is the gas hob running? Those kind of things. And you can see that all of these devices, all this information could be really helpful to the individual and those who care for him. But it's not only clearly personal data, because it's all related to him. This is the way it's doing it. It's actually sensitive personal data. It's relating to his health, a health condition, things that he needs. So there's some very strict requirements under the legislation from a data protection perspective as to what you need to tell him and the chance you need to give to him as to whether he's happy with that or he's not happy with that. Okay, so my third one, smart farming. I like this one. So the farm of the future, and the farm of the future is a very well-resourced farm because in all of his fields he has sensors that pick up moisture and nutrient levels. So the farmer knows where to turn the sprinklers on and not to turn the sprinklers on, where to deliver fertilizer to. Now, any personal data here? Probably not, I'm thinking. It's all related to the farmer's business. Nothing really about him personally. There's no individuals out in the fields who you're taking readings of. So it's not personal data, but it's clearly very commercially valuable data. So would that farmer want that data to be shared with his neighbour farmer over the road? Maybe, maybe not. They might do a trade. Would he want it shared with his suppliers or his customers so they can drive down the prices or drive up the prices? Probably not. Now, the company that's providing the solution, it's probably really helpful data for them, and they probably would want to use that to sell to other services, maybe to aggregate it, to anonymize it. If they're going to do any of those kind of things, they need to make sure that they have the rights to do that kind of stuff with that kind of level of information. So just because it's not personal data doesn't mean that data doesn't raise an issue. Okay. So the data controller. So I mentioned the importance of defining your role. Are you the data controller or the data processor in relation to every single form of processing you are doing with personal data? Very important. Now, most businesses, given the choice, tend to think, oh, no, we're definitely the data controller. It's our data, right? We're the data controller. From a legal perspective, you can't really own data in that way. So from the data protection perspective, these are obligations, not rights. Okay? So it might be better to have a really good think about whether you are the controller or the processor. And if you're not really the controller, then don't try to be. Because if you try to be the controller and you are the controller, then suddenly all the obligations come in. If you are the controller, though, and in many cases, of course, someone's going to be the controller somewhere, and you're engaging processors to do stuff for you, really important that you vet them properly, that you have a proper contract in place. The law mandates that you have at least two things in your contracts with data processors. One is that they don't do anything with the personal data without your consent. And the second, that they have appropriate technical and organizational safeguards in relation to the personal data. And believe you me, if you are data controllers in this room, you want a lot more stuff in there than that. But you need to have at least those two things. You are responsible as a data controller for everything the data processor does for you with the data that they're hosting or processing for you. Very important relationship. Okay, so just highlights of the three main pieces of legislation to think about. So the current regime from a data protection perspective in the UK is the Data Protection Act 1998. There are a number of other kind of smaller regulations dealing with kind of very discrete issues. I've mentioned one there in the middle, which deals with email marketing mainly. So you can't just email or SMS market people just without even warning them or without their consent unless you have an ongoing relationship. There are some specific restrictions on that. And I've also given a flag to the General Data Protection Regulation. So Europe is putting in place a whole new regime in relation to data protection law that's going to apply throughout the whole of Europe. It's not a directive, won't be implemented locally, it's a regulation, so everyone's going to get exactly the same text. Now, this is already the most amended piece of European legislation in history. That's quite some record. And it's still not agreed. Now, the latest thinking is it probably will be agreed in the next week or so, or the start of next year. Implementation period should be 2 years, but they might bring that back to 1 year. When that comes in, the game changes quite significantly. Many of the things I've said already will still apply, but actually one of the main impacts from this perspective is that there will be direct obligations on processors as well. I'm afraid controllers don't get any less obligations, just processors get more. There will be a significant increase in fines. So at the moment in the UK, the maximum amount you can be fined from the regulator in the UK is £500,000, quite a lot of money, for a data breach or for a data loss. That will go up to the higher of 2% of global turnover, or somewhere between 1 and 10 million euros. We don't quite know where the figure's going to end up yet. But you can certainly see for international businesses, fixing the penalty to a more kind of competition law style level of penalty, i.e. percentage of your turnover, suddenly changes the game in terms of the impact of the penalty. And probably two more things I'd say about the new regs. So one is that many more stringent requirements on the level to which you give the individuals control over their data. They need much more information about what you're doing with it, why you've got it, and what they can stop you doing. And very importantly, I think from the Internet of Things perspective, data portability. If they want to move their data from one service to another service, as a service provider, you have to let that happen. So we heard about the Samsung Smart TV. I have one of those. If I buy a new smart TV and I want to move over my favourite channels, maybe the websites that we access from Catch Up TV, under the new regs, I should be entitled to do that. So Samsung has to build a data portability solution to enable me to transfer to Panasonic or whoever else I buy my TV from. Okay, to carry on the theme, this is a bit like Have I Got News For You now. What connects these four pictures? Hacked. Every single one of them. And I could put another 100 pictures up on here, right? And you probably all go, yeah, they've been hacked, they've been hacked, they've been hacked. So these are all obviously pretty recent hacks. You've got the VTech hack. I even saw an article yesterday saying that the phablets, I think they call it a phablet, don't they, is hopelessly insecure. People having deleted their data and sold them on, you can just undelete data. It's not encrypted. There's no security there. TalkTalk, everyone knows about the TalkTalk hack. I'm a TalkTalk customer, so I seen that from a personal perspective and also from a media perspective. Some useful lessons there, I think. Ashley Madison, I'm not expecting anybody to recognise that site at all. Although I was very interested to hear that there are over 10,000 US military government emails registered on Ashley Madison. So Ashley Madison, a website for those who want to have an affair, that was hacked. Sony Pictures suffered the hack by the Guardians of Peace last year. So what's important about this is that the law does not require you to build your systems from a data protection perspective to be hack-proof. You don't have to be 100% secure. What you have to be is have appropriate technical and organizational safeguards. What does that mean? That means that if you get hacked, you have to be in a position to show that you have an appropriate level of security. So consider what the industry is doing, consider what people are saying to you should be doing, and very importantly, understand how you deal with the breach as and when you get hacked. We do a lot of work on reputation management for individuals and corporates post-breach. So some very good examples of businesses that have been breached. Betty's Tea Rooms, I don't know if anyone knows Betty's Tea Rooms, they were breached, data hacked a couple of months ago. Very, very well organised response to it. They got out in front of the problem, they notified everybody, they actually made it a good news story. So actually, we were hacked, but actually everyone could have been hacked because it wasn't our fault, the technical things, we had the right technology in place, but look at how much we're doing, and they used it as an opportunity to actually reconnect with lots of their customers they lost contact with. So they actually turned what could have been a very bad story into quite a good story. So, final comments on mitigating risks. We've talked a lot about security. I think the only thing I would add to that is that from a personal data perspective, collect only what you need to collect. Give it to those only that you need to give it to. And then when you don't need it anymore, you shouldn't hold it anymore. You should delete it. So you treat personal data as a permission to the business rather than an asset of the business. I have this conversation with American clients all the time. For America, they come at the perspective of personal data, that personal data is something the business owns. It's their controlled. Not in the UK, not in the EU. It's a permission you're given as a business, and that changes your mindset as to how you deal with it. Okay, that was all I was going to say.